Next case will be North American Brokers versus Howell Public Schools.
You can keep that.
I didn't have this one.
It's easier to read than this one.
I just didn't.
Where you want it. Oh, thank you. What did I get? Such is life.
Good morning. I'm Stacy Belisle. I'm here on behalf of Howell Public Schools, the defendant appellant.
Please pull the dais up a little bit
yes.
so we can hear you more clearly. Thank you.
Okay. The question before the court today on Howell's application for leave is whether promissory estoppel is an exception to the statute of frauds. And the answer is no. And the reason for that is the legislature, when it drafted the statute of frauds, did not include an exception to the statute in the statutory language. And that should end the discussion there because, based on Michigan's long-standing established rules of statutory construction, if the statute is unambiguous and the language is clear, there can be no exception or, I suppose, policy arguments as to how these statutes should be applied. It should be applied as written. However, here, as the Court of Appeals noted in this case, and as they've noted for a number of years, it seems that the statute of frauds has been treated more like a common law standard as opposed to a statute. And prior decisions of this court have allowed it to, I suppose it's being eaten away by precedent based on the fact that the court has allowed unfairness, unjustness, and absurd results, as we've heard already this morning, to be read into how the statute is interpreted and how it's applied. But the decisions in which these fairness arguments have played into how the statute is applied, in any of those decisions, the court has not weighed or reconciled Michigan's rules of statutory construction against how the statute should be applied. And there's a reason for that, because I believe if this court were to examine that, and I think if the other courts were to examine that, they would see that, in fact, there can be no variation as to how the statute is applied. There are a number of different types of relationships that the statute covers, and when the relationship is not established in a writing signed by the party with authorization to do so, it's void. And that's the clear and unambiguous language of the statute. Now, here we're dealing with a real estate commission. And you could say it's unfair for someone in the plaintiff's position to not obtain a commission for whatever work that they did in this situation. But the problem is the statute of frauds addresses that. And that's what the trial court recognized and the Court of Appeals grappled with.
Counsel, good morning.
Yes.
And welcome. But was there a certain level of reliance at all that was present in this case?
Well, that's going to be the argument in any of these situations where a promissory estoppel or an estoppel is pled or argued that there was reliance. And that's why the statute of frauds is so important. Because in any case like this, the party claiming an entitlement to something is going to say that they relied. So the legislature very specifically said, okay, in these types of circumstances, there must be a writing, because it's going to be confusing to try to determine, based on a reliance argument, who gets what and who is bound by what. If there's not a writing, as the legislature sets forth, the claim is void.
How have we survived so long with these equitable exceptions to the statute of frauds? And I guess to broaden that out, how have we in almost every other jurisdiction, including England, where the statute of frauds originated, how did they survive?
Well, I think that the court is getting there, and I think this is the case in which it's time for this court to make this decision and to clarify that the rules of statutory construction do not allow for an absurd result.
If it's so problematic, how? It's hard for me to wrap my mind around that. Your argument, I think, is this is causing a lot of problems, right?
It's inconsistent. There's muddled law. The Court of Appeals doesn't know what to do, dating back to 2003 in the Kelly-Staney decision.
Don't we have a unanimous opinion in Updike that tells the Court of Appeals what to do?
I believe that that is something that it is appropriate now for this court to overrule, and based on the role of precedent and what this court can do when there is confusion, other decisions have said that when a prior decision of this court is causing inconsistent decisions and confusion, it's appropriate for a later court to reverse or overturn or clarify what that prior decision did. And I would argue that, of course...
What's the confusion that's being caused?
The confusion that's being caused is the tension between the clear language of the statute of frauds and the fact that courts are judicially legislating into the statute of frauds an exception that the legislature did not provide for. And so while
Counsel, that sounds like an argument for why maybe Optech shouldn't have come out the way it did when it did. But I think Justice Viviano is asking you, can you give us some evidence of opinions from the Court of Appeals that shows this disruption or confusion that you're...
Oh, absolutely. Yes, absolutely. In the Kelly-Staney decision in 2003, which we cited in our brief, which was actually authored by now Justice Zara, in that case, the Court of Appeals expressed difficulty in applying Updike and wanting to actually abide by the rules of statutory construction, but felt constrained, as the Court of Appeals did in this case, to apply the exception because that was the rule that they felt they had to follow.
So they followed the rule and just thought it wasn't a good rule. I wish I could say there were other... I've never read an opinion by this court that I thought was imperfect. That happens, but I still haven't heard what the... It sounds like the Court of Appeals was able to apply it.
They were able to apply it, but they didn't want to. And the court expressed that...
So we should fix problems when the Court of Appeals doesn't like our precedent? That's the...
No, but what's been happening, as I've seen in this court, is there's been a progression toward correcting the application of statutes where this court has previously read an exception into it, and that's McIntyre, Jones, Gilbert, Johnson, I believe, is another case. In 2016, in the Jesperson case, this court also corrected the incorrect application of a statute based on the absurd result rule or fairness or equity. And so I think the court is getting there, and it seems in reviewing this court's case law, as it's progressed in the last 10 to 15 years, is when a statutory provision that is clear and unambiguous comes before it, and it sees that prior decisions of this court or the Court of Appeals have applied it in a way that reads an exception into the statute that doesn't apply or doesn't belong there, this court has been correcting those decisions and kind of circling back around and bringing the state's jurisprudence back to where it should be, which is respecting the rule of statutory construction. And I believe now that this case is before the court, it's time for the court to also correct the differing and confusing opinions as to how the statute of frauds is applied. And I think we're there, and I think this is just the natural progression of the court. And I think if this judicially legislated exception to the statute of frauds is allowed to stand, it seems that other parties will in the future attempt to utilize it in order to attack other statutory provisions that have up to now been applied in a particular way. And coming to mind is something such as the governmental immunity statute in Michigan. You could clearly argue that when that is applied, it produces an unjust, unfair, or potentially absurd result because it cuts off every tort claim that a plaintiff may have against a governmental official. Well, why can't a plaintiff then come and say, well, based on Updike, based on this case, based on other cases,
Do you believe that all the equitable exceptions to the statute of frauds should be removed?
Yes. Yes.
And do you think that some of those go back, one at least, to equitable estoppel to 1887. Do you think that would cause any disruption if we were to alter precedents that go back that long?
I don't. I don't. The rules of statutory construction date back to the 1800s in Michigan. And I believe that allowing what's going on here, which is an exception being read into the statute that shouldn't be because the legislature didn't draft it, I think that's much more of a disruption because we end up here again. And as I said, I feel that it's going to allow parties to try to eat away at the integrity of every statute in the state of Michigan.
When we look at overturning our cases, we have to think a little more about whether or not the case was correctly decided, whether the language tracks the statute, right? We have to look
Certainly.
at reliance interests and other effects on the marketplace and on people who are operating in accordance with the law and the rules as they've been handed down by the legislature and this court. And so I guess that, back to my original question, is it your position that this is just not working?
Yes. Well, it's not just that it's just not working, it's that it is completely contradictory to the way that Michigan interprets, applies, and reads
I understand
statutes.
your position. That's a different argument. You're saying it departs from the statute, we should fix it. I get that. And generally, I agree with that. But in this case, the statute of frauds, as it was originally enacted in England a couple of 100 years ago, had these exceptions, and it's developed with these exceptions in Michigan and almost every other jurisdiction. And so the position you're taking, to my vantage point, is a little bit of a radical one. And I'm just asking you, is it because you think this isn't working, and therefore we should overturn a unanimous 40-year-old precedent to hew closer to the language of the statute? Or is it just the fact that it isn't what the statute says?
Well, I think it's both. I think it is because it's not what the statute says. In Michigan, I don't know that in pleading a claim for promissory estoppel that a plaintiff is looking at the history of the statute of frauds dating back to England. So I believe what we have to do is look at what, as you said, what the legislature says, and in order to prevent confusion in future decisions and to ensure that parties are not able to somehow mount a collateral attack on any other statute in the state of Michigan.
Can you envision a contractual relationship that parties enter into where they are relying on promissory estoppel? I mean, we're talking about reliance interests, and there's this exception to promissory estoppel. People are relying on that. When two people enter into a contract, do you really think they're relying on promissory estoppel in the back of their minds to avoid the contract?
Well, one would hope not. No, I think what they're relying on is, I don't know. I mean,
the words
I
of their
suppose
contract, would you think? Or the statute that says it should be in writing?
Yes. Yes. I believe that is
So
what
is there any
they're...
concern about reliance on case law of promissory estoppel with regard to the jurisprudence of contracts, that there's more certainty if we rely on the statute and the words of the contract as opposed to a equitable doctrine?
Absolutely, and I think that's what I've tried to say in terms of the fact that I think that allowing this result to go forward would create more confusion than clarity.
In the Crown Tech Park case that I wrote in the Court of
Yes.
Appeals, I did specifically focus on the amendment to
Yes.
the statute of frauds to address that case. And opposing counsels made a pretty interesting argument that if we apply the rules of statutory construction that you're advocating here today, that amendment, only with regard to the banking issue, would preclude us from finding or concluding that Updike was wrongly decided. How do you respond to that?
I respond that both provisions of the statute of frauds that are at issue in Crown Tech Park have unambiguous and clear statutory language, just as Section 2 states that an action can't go forward on a claim regarding an unwritten contract for banking institutions. The language is just as clear in Section 1 that states that any agreement, promise, or contract that's not in writing and signed is void. And so I think the principles that are set forth in that decision are equally applicable to Section 1 when you have clear and unambiguous language.
Then would the amendment that was enacted be unnecessary to the decision, to the result? What was the purpose of the amendment?
Well, the purpose of the amendment, I believe, was to add an additional type of contractual agreement that the statute of frauds was going to be applicable to, as opposed to attacking the first section, which obviously spells out various different types of contractual relationships. I think it was to add another one. The legislature used different language, but it can do so. That doesn't mean that it meant anything with respect to Section 1. It just means that it added something in Section 2.
Counsel, in Opdyke, this court justified what it was doing in disregarding the precise language of the statute of frauds on the basis that it was, by injecting the idea of various forms of estoppel, it was avoiding arbitrary and unjust results, that equitable loopholes were required, otherwise the outcry would soon be such that the statute of frauds would be amended in short order, and that it was overly mechanistic. If we were to do what you're suggesting, what is your sense as to whether or not these things would then come to the fore, that we would see increasingly arbitrary and unjust results occurring as a result of the restoration of a statute of frauds unmodified by the various safety valves that have been introduced into it?
I do not feel that there would be a public outcry. I don't think there would be an overly mechanistic application of the statute of frauds, and I think that was dealt with by the dissenting opinion in the Lovely case, in which the court, the dissenting justice stated, of course there's going to be unfairness. Of course the result could potentially be unjust. But that's what the statute of fraud says, and that's what's going to happen, and that's the statute that we have, and that's what we have to deal with.
So you accept the premise that the statute of fraud does in fact produce unjust results, but we just have to live with those?
Yes, I think that any statutory provision such as that one could produce unjust results. I think our governmental immunity statute, some would argue, probably produces unjust results as well. But until and unless the legislature amends it, then that is the statute that we must live with.
Thank you. Okay, thank you very much.
Thank you.
Good morning. May it please the court. I'm Richard Shaw. I'm unaccompanied.
Good morning, Your Honor. Ali Kusan for the public.
As I listened to the oral argument that preceded me, I find myself thinking that the court is fully aware of all of the issues. I would like to discuss...
Is that surprising?
And in conclusion?
Justice, believe me, I've genuinely thought about that, but I have a client in the back. Justice Markman asked about the safety valve. And I'd like to remark on one. This is a momentous issue that's before the court. I actually stopped and asked myself, what am I doing here? If we go in the direction advocated by defendant, it's not just this statute. It's also the 566.106 on the sale of land. It's also 566.108 on leases in excess of 1 year. And I have the feeling I haven't even scratched the surface. Not to mention there are 7 different aspects to the statute of frauds that I am directly applying. Let me just call your attention to one case that's in my brief. A woman is promised by a man, if you marry me, I will support your children, or especially one child. Not the man's child. And she does marry him. And there's a divorce. And I don't want to mislead the court. There were other reasons for the outcome in that case. But one reason was that promissory estoppel is an exception to the statute of frauds. Because the statute under, does that mean I'm about to be interrupted? The statute under consideration precludes a promise upon consideration of marriage. and she would not have had enforcement under the statute of frauds, although there was other reasoning in that case. This is such a momentous issue before you. I can't believe that it's been under the radar and you haven't been inundated by amicus curiae briefs. And so if you are at all considering giving defendant the relief they're requesting.
Well, counsel, actually, good morning and welcome. You mentioned amicus briefs, and the realtors are quite concerned about this because they think it could jeopardize the idea of single listings. So, you know, since you kind of brought it up, I guess it would be helpful to you to respond to those concerns.
I'm not sure I got the question. I'm sorry. Am I hearing
The
this a little bit?
Realtors Association brought forth an amicus brief that basically was quite concerned over your position. So I guess I would love for you to take this opportunity to perhaps address that since you kind of brought that to light.
Well, I think that association is particularly concerned with their automated service, the one that works through the internet. And I frankly think that this is a question of looking where the money is. And they would like not to have the safety valve that is in place here.
Well, I guess their concern is that it could jeopardize the idea of a single listing, that if a person, you know, opts to have a single listing, then your position could ultimately make that difficult on people who are trying to sell properties.
But I think we're misdirecting our attention. The focus should be on a defendant who puts up a sign that says, brokers protected. It doesn't say, please call. Brokers, call me. Brokers, I'm interested in hearing from you. But instead used language, brokers protected, which we intend to show at trial, and I understand it's not a fact of this case, that explicitly is an offer of a unilateral contract and says, this unilateral contract is accepted by performance. And I appreciate the fact that the amicus curiae is concerned that certain problems may arise. And maybe...
But counsel, what about the idea that, you know, your client had reached out to the school district on a number of different occasions and had said, you know, hey, you know, I'd like to, you know, he'd kind of asked for this and they chose not to put anything in writing. I mean, I guess the question I have is that, you know, ultimately your client kind of began work, did all this types of stuff. His calls kind of in terms of, you know, the fact that he had asked for this to be on writing weren't returned in terms of the contract, but then he kind of went ahead anyways, you know, to kind of perform. So I guess my question is that isn't there a certain level of risk from the idea that if I ask you for a contract and you don't return my call and then I kind of continue to go out and, you know, do the work, even though the school district hadn't returned the phone calls, isn't there a little indication at some point that maybe they aren't interested in kind of going into an exclusive relationship?
Respectfully, Justice Bernstein, we have a situation here where there is no record whatsoever. There's a complaint and there's a motion to dismiss based only on the complaint. If it turns out that the facts develop more or less in the scenario that you have described, it may well be that my client will not succeed in his position. He will not perhaps succeed in promissory estoppel, or he will not succeed in raising the doctrine of equitable estoppel as a bar to the statute of frauds. He may lose, but from my perspective, what we have here is we have the possibility that defendant is going to be seen as a cynical opportunist.
Well, hold on just for a second. Your client was charging a 9% fee, correct?
Aspirationally.
Okay. What is industry standard?
May I consult?
Sure.
Do you have an idea of industry standard? 8%, Your Honor.
Okay, so 8%, so it's an 8% is industry standard as it pertains to it. So let me just kind of put this together. For the plot of land that you're looking at, ultimately, in terms of helping to show a plot of land, we're looking at a school. Let's just say it's $1 million. I'm just estimating. So that's a very good profit motive, isn't it? A profit. That's a nice profit.
It is.
Okay. So, I mean, ultimately, I guess the question I would kind of, put back, towards this is that when you're dealing with something at the level that we're dealing with, isn't that the essence of why the statute of frauds exists?
I am not here to suggest that the statute of frauds is always a bad law. I am here to suggest that it is not a good idea to strike down all equitable aspects that bear on the statute of frauds, A through G, and that such a sweeping pronouncement is a terrible idea, and yet in the posture of this case, I don't see how you can do anything else. And you should deny leave if only because you have an undeveloped record, and all of your questions as to whether this is the right case for promissory estoppel would be resolved better if there were a developed record. But again, all we have is a complaint and an immediate motion.
So that would be a sweeping reform, more sweeping, I assume, than a reform that looks to the language of the statute of frauds, disregards the word agreement, disregards the word promise, and disregards the idea of a contract, and allows courts to substitute the judge's own sense of justice and the judge's own sense of discretion for that of the legislature. That's considerably less sweeping, no doubt.
In this context, yes, where there have been 5 enactments, and each time the same language has been used by the legislature, and in each case, nobody within the legislature, to my knowledge, and I know I am completely aware of the hostility to the doctrine of legislative acquiescence. That certainly hasn't gone by me.
Okay, well, we're familiar with it as well.
But
Let me just take you down a different road. We do have a longstanding precedent, and under the Robinson factors, we consider more than whether we think it was rightly or wrongly decided. And one of the primary things we look at also is the reliance, the reliance in the community and in our state on this rule. Can you articulate for me what kind of reliance could possibly be out there for parties who are contracting? In other words, 2 parties want to make a contract. How can they possibly rely on the notion that, well, if I don't like what I've gotten into, there's always the chance I can have promissory estoppel to get me out of it? Don't parties instead, when it comes to a contract, rely on the word of the contract?
And they did.
I don't see how there can be any reliance on promissory estoppel to set aside a contract.
I am not suggesting that plaintiff relied on the doctrine of promissory estoppel.
No, but in our consideration of whether to reverse precedents, one of the things we consider is it right or is it wrong? And if it's wrong, should we reverse it if the world has relied on this? And so my question is, who could possibly, in the world of contracts, who could possibly rely on the notion of promissory estoppel to set aside an agreement? Or to create an agreement where there was none?
Your Honor, I don't think that stare decisis rises or falls with the notion that somebody somewhere relied on a series of cases, all of which are in my brief. I think stare decisis is far more significant than that. It is a judicial philosophy that we give the state of Michigan a sense of credibility as to past decisions. As the Supreme Court said in Payne versus Tennessee, it is the backbone of, it promotes the even-handed, predictable, and consistent development of legal principles. I think to suggests that stare decisis should be ignored because my client did not explicitly think about promissory estoppel when he accepted the invitation to promote the sale of this property. Misses the point. The point is, in my view, respectfully, that the lawyers and the public will now see that stare decisis is meaningless. If ever there's a case for stare decisis, I suggest to you that this is it, where the legislation has been enacted 5 different times, starting with soon after after Michigan became a state. And I take it that means I have about 10 seconds.
2 minutes.
I thank
less
you
than
for
2
your
minutes.
attention.
Go ahead.
2 minutes.
Oh,
And
2
you
minutes.
just lost 10 seconds.
Actually, I think I might as well stop there. If there
Leave
are,
me hanging. That's okay. Something tells me I wasn't going to
this is the
totally
case to
understand the
maintain
answer
stare
anyway.
decisis. Thank you very much for your attention.
Are there any further questions? Thank you very much, Mr. Shaw.
Thank you.
This case will be submitted. Thank you for the arguments, both